start the concept of bail, which is a basic part of the Indian criminal jurisprudence, and it is well recognized principle among all the judicial systems of the world. Bail in law means procurement of release from prison of a person awaiting trial or an appeal, by the deposit of security to ensure his submission at the required time to legal authority. The monetary value of the security, known also as the bail, more accurately the bail bond, is set by the court having jurisdiction over the prisoner. The security may be cash, the papers giving title to property, or the bond of private persons of means or of a professional bondsman or bonding company. Failure of the person released on bail to surrender himself at the appointed time results in forfeiture of the security. Courts have greater discretion to grant or deny bail in the case of persons under criminal arrest. The law lexicon defines bail as the security for the appearance of the accused person on which he is released pending trial or investigation. What is contemplated by bail is to procure the release of a person from legal custody, by undertaking that he or she shall appear at the time and place designated and submit him or herself to the jurisdiction and judgment of the court. The Criminal Procedure Code 1973 does not define bail, although the terms bailable offence and non-bailable offence have been defined in section 2 (a) CRPC as follows. Bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being enforced, and non-bailable offence means any other offence. Stop. Further, sections 436 to 450 set out the provisions for the grant of bail and bonds in criminal cases. The amount of security that is to be paid by the accused to secure his release has not been mentioned in the CRPC. Thus, it is the discretion of the court to put a monetary cap on the bond para. The preliminary purposes of bail in a criminal case are to be relieved the accused of imprisonment, to relieve the state of the burden of keeping him, pending the trial, and at the same time, to keep the accused constructively in the custody of the court, whether before or after conviction, to assure that he will submit to the jurisdiction of the court and be in attendance thereon whenever his presence is required. Stop.